we do about the criminalization of homelessness? We know it's ineffective, we know it's expensive, we know that it creates so many other harms. Well, one of the things that the Law Center does is we fight against it in court. And one of our cases is Martin v. City of Boise. We litigated this case with Idaho Legal Aid and pro bono counsel at Latham and Watkins. It was filed many years ago and went through a number of procedural rounds before we finally got a decision on the merits from the Ninth Circuit, which is the highest federal court in the western United States, in late 2018. The City of Boise asked the Ninth Circuit to review the decision, and they chose not to, but in choosing not to review that decision, there was a concurring opinion that was issued by Justice Berzon, and that was April 2019. And that is the opinion that I would ask everyone to read if you're going to be making arguments about Martin. What was that name again? It's Martin v. City of Boise, and there's two opinions, one from September 2018 and one from April 2019. It's the April 2019 opinion that has superseded. Having said that, the rationale in the 2018 opinion is still good. But when we talk about some of the things that Martin does and the things that Martin does not do, I'm referring to what is in the April 2019 opinion, where Berzon, for better or worse, emphasized the narrowness of that decision. So that's something for advocates and people experiencing homelessness to understand. Martin does forbid criminal punishment of sleeping, sitting, lying down when shelter is unavailable. Martin was an as-applied challenge, meaning the camping ban and disorderly conduct laws that were challenged in the Martin case were not invalidated on their face, meaning there was not an argument that you can't have a law like this at all. It was you can't enforce a law like this or laws like these against people who are living outside and who lack any indoor place to perform these unavoidable, universal activities: sleeping, sitting down, and lying down. What Martin does not, and here's where I imagine we're going to get most of the questions, it does not establish a right to camp. It is explicit about that. It does not provide the freedom for any individual to determine when, where, and how they sleep, sit, and lie down outside. Governments are still free to regulate public space and to regulate those activities as performed in public space. It also doesn't require cities to establish shelter or to establish housing. It restrains them from punishing people criminally. Now, Martin is, and it's explicit about this, is a narrow decision. It's an important one, but it's a limited one. It's narrow. But it does enunciate a principle. And that principle is one that has not only been articulated by the Ninth Circuit, but also by other federal circuit courts. The 4th, 5th, and 11th circuits. So, what does that mean? Well, there was a lot of discussion about whether or not Martin would remain good law, because the City of Boise, as they asked the Ninth Circuit to revisit the decision, asked the Supreme Court to visit the decision. And in December of last year, the Supreme Court declined to do that. Now, what that means is it's a tacit acknowledgement of the fact that there is not a difference between the rationale in Martin and Supreme Court precedent. And there's not a conflict between these other circuits. That's important for a variety of reasons, but I guess the takeaway here is Martin is binding law, and there's possibly a chance that the Supreme Court will revisit this issue. But unless and until they do, all governments in the Ninth Circuit, and that's where we are bound by its holding. And it establishes a principle, and that principle is when somebody is punished for engaging in universal, unavoidable conduct in public space and they lack an adequate alternative, there's a violation of the 8th Amendment's cruel and unusual punishment clause. We could talk about the shape of that and what that might apply to, because I'm guessing you're going to have a lot of questions about that. So, in addition to notifying you about the report, it's a great place for data. If you're crafting arguments, I think you're going to find a lot of good references there. Helps give you a national snapshot. We'll talk more about Martin in the Q&A, but I wanted to point out some good and bad things happening at the federal level. So our position at the Law Center is housing is a human right. And it is a human right. It's an internationally recognized human right.